The concept of Waqf holds a significant place in Islamic tradition. It represents an enduring act of charity, a dedication of property for the betterment of society. Waqf properties, endowed for religious, educational or charitable purposes, serve as a testament to the philanthropic spirit of the Muslim community. However, over time, the management and administration of these valuable assets have faced challenges, necessitating legal frameworks to ensure their proper utilization and protection. In India, the Waqf Act of 1995 emerged as a cornerstone legislation aimed at streamlining the administration of Waqf properties and ensuring their rightful use for the intended beneficiaries. This landmark act sought to address historical issues of mismanagement, disputes and encroachments that had plagued the Waqf system for far too long. The Act's preamble eloquently outlines its noble objectives: to provide for the better administration of Waqf and for matters connected therewith or incidental thereto. This simple yet profound statement underscores the Act's core purpose: to safeguard and optimize the management of Waqf properties for the collective good. The 1995 Act represented a significant step towards reforming and revitalizing the Waqf system in India. It provided a comprehensive legal framework, laying down clear guidelines for the management, development and protection of Waqf properties across the country. Prior to the enactment of the 1995 Act, Waqf properties in India were governed by a patchwork of laws and regulations, leading to inconsistencies and ambiguities in their administration. The absence of a unified legal framework created loopholes that were often exploited, resulting in mismanagement, misappropriation, and neglect of these valuable assets. Recognizing the urgent need for reform, the Government of India embarked on a legislative endeavour that culminated in the passage of the Waqf Act 1995. This landmark legislation aimed to consolidate and streamline the existing laws governing Waqf properties, bringing them under a single, comprehensive framework. The 1995 Act sought to address several key challenges that had plagued the Waqf system. One of the primary objectives was to curb the widespread mismanagement and misappropriation of Waqf properties. The Act aimed to achieve this by introducing greater transparency and accountability in the management of these assets. Another critical aspect of the 1995 Act was the establishment of a dedicated institutional mechanism for the administration and supervision of Waqf properties. The Act paved the way for the creation of central and state Waqf boards, entrusted with the responsibility of overseeing the management of Waqf properties within their respective jurisdictions. The 1995 Act marked a watershed moment in the history of Waqf administration in India. It provided a much-needed legal framework, laying the foundation for a more transparent, accountable and efficient system for the management and utilization of Waqf properties. The Waqf Act of 1995 introduced several key provisions that formed the bedrock of its regulatory framework. These provisions aim to strengthen the administration of Waqf properties, promote transparency and ensure their proper utilization for the benefit of the community. One of the most significant provisions of the Act was the establishment of the Central Waqf Council. This apex body, constituted at the national level, plays an advisory role to the Government of India on all matters related to Waqf. The Council comprises experts in various fields, including Islamic jurisprudence, law, finance, and administration. At the state level, the Act mandated the formation of state Waqf boards responsible for the administration and supervision of Waqf properties within their respective states. These boards are empowered to appoint mutawallis or managers for individual Waqf properties, ensuring their proper upkeep and utilization. Recognizing the importance of accurate and up-to-date records, the Act made it mandatory for all Waqf properties to be surveyed and registered with the respective state Waqf boards. This provision aimed to create a comprehensive inventory of Waqf properties, preventing encroachments and facilitating their effective management. The 1995 Act also introduced mechanisms for dispute resolution, recognizing that legal disputes related to Waqf properties were not uncommon. The Act provided for the establishment of Waqf tribunals, specialized judicial bodies empowered to adjudicate disputes related to Waqf properties, ensuring a fair and timely resolution. 3 decades after the enactment of the Waqf Act, 1995, the need for a comprehensive review and amendment became increasingly apparent. While the 1995 Act had laid a strong foundation for Waqf administration, certain shortcomings and emerging challenges necessitated a fresh perspective and legislative intervention. The Waqf Amendment Act of 2025 was introduced with the aim of strengthening the existing legal framework, enhancing transparency, and improving the overall governance of Waqf properties. The amendment sought to address concerns related to accountability, digitalization, and modernization of the Waqf management system. One of the key drivers behind the 2025 amendment was the need for enhanced transparency and accountability in the management of Waqf properties. The amendment introduced provisions to strengthen the financial reporting and auditing mechanisms of Waqf boards, making them more answerable for their actions. Another critical aspect of the 2025 amendment was the focus on digitalization. The amendment mandated the creation of digital databases and online platforms for the registration, management, and monitoring of Waqf properties. This move aimed to streamline administrative processes, enhance accessibility of information, and reduce the scope for manipulation or fraud. The 2025 amendment represented a significant step towards modernizing and strengthening the Waqf management system in India. It reflected the government's commitment to ensuring the proper utilization and protection of Waqf properties for the benefit of the community. The amendments to the Waqf Act have brought about several positive changes. Firstly, they have ensured greater transparency in the management of Waqf properties. This in turn has led to better utilization of these assets for the community's benefit. Additionally, the amendments have strengthened the legal framework, providing clearer guidelines and reducing ambiguities. As a result, there has been a significant reduction in disputes and litigation. Overall, these changes have paved the way for more effective and efficient governance of Waqf properties, ultimately contributing to the socio-economic development of the community. Now let's delve into the negative repercussions that have emerged due to certain amendments in the Waqf Act. These changes, while intended to streamline processes, have sometimes led to unintended consequences. For instance, the centralization of power has occasionally resulted in local communities feeling disempowered. Moreover, there have been instances where the lack of clarity in the amendments has led to legal ambiguities, causing prolonged litigations and disputes. To illustrate these points, let's consider a case in point. In one notable instance, a local Waqf board faced significant challenges when trying to reclaim a property that was unlawfully occupied. The amendments had shifted certain powers to a higher authority, which delayed the resolution process. This not only frustrated the local community, but also strained the resources of the Waqf board. Such cases highlight the practical difficulties that arise when the legislative intent does not align perfectly with on-ground realities. Implementing the Waqf Act and its amendments has not been without its challenges. One major hurdle is the lack of awareness and understanding among stakeholders about the new provisions. This often leads to misinterpretations and misapplications of the law. Additionally, the bureaucratic red tape can be overwhelming, making it difficult for Waqf boards to operate efficiently. Another significant challenge is the resistance to change, particularly from those who benefit from the status quo. Striking a balance between the intended benefits of the amendments and their practical implementation is crucial. It's essential to ensure that the reforms do not alienate the very communities they aim to serve. Continuous dialogue between lawmakers, Waqf boards and local communities can help in fine-tuning the legislation. Moreover, providing adequate training and resources to those involved in the implementation process can mitigate many of the challenges. Ultimately, the goal should be to create a framework that is both legally sound and practically viable.